What's the proper way for a trial judge to address the risk of reoffense by a sexual offender? To find out, you have to read People versus Anthony, but it's 28 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, New York Court of Appeals cases in 5 minutes or less if I can do it. This is the episode on the case of People versus Anthony. The citation for this case is 2023 New York Slip Opinion 03303, published by the New York Court of Appeals on June 15th of 2023. The issue in this case is the proper way for a trial court to address a SORA adjudication, a Sex Offender Registration Act adjudication, to determine what level sex offender an offender should be, level 1, 2, or 3. The law you have to understand to appreciate what's going on in this case. It's a little more complicated. Basically, after a person has been convicted of a sex offense, the law, Corrections Law 168, requires that a court conduct a SORA adjudication. It's not a penal adjudication. It's not an adjudication to punish an offender. It's an adjudication to determine future risk and what level of notification the public should have about this offender, the sex offender. So the section of law 168 of the correction law requires that the Board of Examiners of Sex Offenders prepare a risk assessment instrument. It's basically a checklist. It has a bunch of different factors, and they go through the factors, and they determine, in factor 1, the defendant gets 10 points. In factor 2, the defendant gets 0 points. In factor 3, the defendant gets 10 points, whatever it is. And at the end of the day, after that risk assessment instrument is prepared, if the defendant gets 70 or less points, or less than 70 points, it's level 1. 70 to 110, it's level 2, and more than 110, it's level 3, presumptively. That's the presumptive level. And at that point, there's two other things to consider. The hearing actually involves several things. The risk assessment instrument, presumptive level. Then there's the ability for an override. So in certain circumstances, it's kind of rare, there's a presumptive override where it automatically goes to presumptive level 3. And that's if there's a prior felony for sex crime, if there's a recent threat to reoffend with a sex crime, if there's a clinical assessment that the offender has a psychological, physical, or organic brain abnormality that reduces their impulse control with respect to sexual behavior. Any one of those circumstances are present, it goes to level 3 presumptively. And lastly, the last part of it's the part that's important to this case. At that point, the defendant or the prosecution has the chance to ask for a downward departure or an upward departure. A downward departure says, I know he's presumptive level 2, but I think you should make him a level 1. Or an upward departure says, I know he's a presumptive level 2, but I think you should make him a level 3. And there's a case called People versus Galati that goes through the analysis the court has to conduct when assessing these downward or upward departures. And there's 3 parts to the test. The first is the party seeking the departure has to identify either a mitigating or an aggravating factor that changes the risk that the judge should consider, and whether this mitigating or aggravating factor is of a kind or to a degree not adequately addressed by the risk assessment instrument. So does the risk assessment instrument not already address this? Number 2, whether the circumstance has been proven to the proper proof. Now, for an upward departure, you need clear and convincing evidence, and for a downward departure, you need preponderance of the evidence. And lastly, based upon the totality of the circumstances here, does it warrant either the downward departure or the upward departure that's being sought? Okay, that's the basic law you have to understand about SORA adjudications. What are the facts here? The facts are, in 1988, the defendant raped and sexually assaulted 5 women in their homes at knife point during burglaries over the course of a year. So a serial criminal here. The defendant was convicted after trial of 4 counts of first-degree rape and 1 count of criminal first-degree sodomy. And he then had a SORA hearing. And at the SORA hearing, they had a risk assessment instrument that gave him 155 points. Now, that's more than 110. So it's presumptively level 3. He didn't dispute, the defendant did not dispute that risk assessment level, but he asked for a downward departure on a bunch of different bases, including his age, his family support, his lack of history of disciplinary infractions, the positive performance on sex offender treatment education, and other factors. The trial judge denied the application, saying, well, some of these are already addressed by the risk assessment instrument. And he also applied the wrong standard. He said, It's not been proven by clear and convincing evidence, but that's not the right standard for a downward departure. It's preponderance of the evidence. The appellate division affirmed, but corrected that standard of proof issue, and it goes to the Court of Appeals. Now, here we have the Court of Appeals. It's interesting. There's a majority and a dissent here. The majority and the dissent have different issues they're addressing. The majority says the only question here is whether the defendant was entitled, as a matter of law, to the downward departure he sought. And the court says no. In light of the severity, the number, the circumstances of these underlying offenses, no, you don't get the downward departure. So they sort of say the totality of the circumstances, they latch onto that part of the appellate division decision and say no, he is not entitled to it as a matter of law. But there's a dissent here, and the dissent is judged by Judge Rivera, and it's a very interesting dissent. She says the issue that the majority is addressing is the wrong issue. That's not the issue presented in this case. The issue presented is whether the fact that the defendant has his arguments for mitigation were like his age, his lack of disciplinary action, his family supports. These things are addressed as factors in the risk assessment instrument. And the trial judge said, well, these are adequately addressed already. But she said, no, that's the wrong way to think about it. The dissent says the risk assessment instrument is a one-way ratchet. It measures aggravating factors. So if this factor is present, it's an increased risk. If this factor is present, it's an increased risk. And it only goes up. So the fact that for the defendant to say, well, this issue that's already addressed in the risk assessment instrument is actually to my benefit, Judge Rivera says, well, that's not adequately addressed in the risk assessment instrument because it's only addressing risk. It's not addressing mitigation. So nothing in the risk assessment instrument is adequately addressing a mitigation argument for downward departure, according to Judge Rivera. It's a one-way ratchet. It doesn't consider the downward aspect of a mitigation. So Judge Rivera would say that nothing in the risk assessment instrument adequately addresses mitigation of those factors. And that's the case of People versus Anthony. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.